Welcome to U.S. Immigration TV. I know there are many U.S. citizens who want to petition their parents to join them in the U.S. Perhaps they are grateful to their parents for giving them life on this planet, and they hope to repay their parents in some small way by giving their parents life in the U.S. Or they may have recently had a baby, and their parents would make the perfect nannies while they go to work, leaving the child in the care of the grandparents. But what happens if one of the parents committed fraud or perhaps was charged with fraud in the past? Maybe they applied for a visitor visa and lied on the application, or they may have submitted fake or manufactured documents and they were caught, or they may have tried to enter the U.S. under an assumed name. Well, now that fraud is on their record. So, when the parent is petitioned and eventually goes to the embassy for their immigrant visa interview, that old fraud comes up and the immigrant visa is refused or denied because of that fraud. And I know the whole family is devastated because now dreams are crushed and the future is uncertain for that parent. Well, is there hope? Is there anything that can be done? Well, I've encountered this situation so many times in the past. And while I'm not guaranteeing success or results, there are several things that can be done for that parent. Basically, what can be done is to have the other parent immigrate first and then file a fraud waiver or hardship waiver for the remaining parent who had been charged with fraud. Now, by way of background, if any person commits fraud, they are considered inadmissible or ineligible to receive a visa. Before 1996, that fraud would be erased from their record after 10 years. But in 1996, President Clinton signed a law stating that the fraud stays on the person's record forever. Now, the person would need to file a fraud or hardship waiver if charged with fraud, basically asking the USCIS or U.S. Immigration and Immigration Services for forgiveness, by demonstrating that a qualifying relative, that's important, the phrase qualifying relative, would suffer extreme hardship if that person is not allowed to immigrate. Well, who is a qualifying relative? Well, qualifying relative for purposes of fraud or hardship waivers includes the spouse or parent who is either a U.S. citizen or a lawful permanent resident. Only those two, not children who are citizens. Only spouse or parent who's a citizen or immigrant. Well, what's extreme hardship? Well, extreme hardship can be a very confusing and complex concept and really is difficult to document and prove on your own. In fact, there is a whole chapter in the USCIS policy manual discussing extreme hardship, what factors are taken into consideration, and the type of proof necessary. One of the main factors in demonstrating extreme hardship is how a qualifying relative would suffer extreme hardship if they had to relocate from the U.S. or the hardship they would suffer as a result of separation. So hardship because of relocation or separation. Now, in the situation we are discussing, where an adult U.S. citizen child is petitioning a parent who is charged with fraud, that parent may not have a qualifying relative to enable them to even file a hardship waiver. They may not have parents who are citizens or immigrants, and of course they were intending to immigrate along with their spouse. However, in order for there to be any kind of hope or chance for success, they must have a qualifying relative first, or they cannot even file a hardship waiver. So that's why I suggest that in these situations that the other spouse or the other parent of the child immigrate first, and then they become a green card holder or lawful permanent resident. As soon as they have their green card, they can now become a qualifying relative, enabling the other parent who was charged with the fraud to file a hardship waiver. I mean, we can still use the child's petition, but it is the other spouse who will be the qualifying relative for the fraud waiver. Well, they may temporarily, of course, be separated. I think that that brief time period is well worth the sacrifice to enable both parents to finally and eventually immigrate to the U.S. Now, if this situation applies to you, your family, or even to someone you know, I would suggest that you consult with an attorney who can evaluate your situation and recommend the best course of action, including helping you gather documents, prepare declarations, and file a hardship waiver to enable you to finally bring both parents to the U.S. I hope you have found this video helpful and informative. And as I say, I will continue posting videos which I hope you will find informative and helpful to you and your case. So therefore, please make sure to like, share, and most importantly, subscribe to this channel. I'm Michael Gurfinkel, and thank you very much, really, for watching U.S. Immigration TV.